Hello everyone in BRE 140. My name is Andrea Genzo. I'm going to be covering chapter 4 of our textbook, which was called Most Important Lease Clauses. Um, Chapter 4 covers the importance of utilizing a standard form lease to make the administration of leases an easier process. The lease clauses are specific details in the lease that pertain to the rented property that complement local state laws. Fixtures and the three basic tests to determine if an item is a fixture, I found to be very important to remember. Um, the clause on lead-based paint was very important and duly noted as it is necessary to know as a future investment owner myself and required by law. The last concept that I found interesting was the quiet enjoyment clause and the way the owners can breach that clause. Say the first key concept that I'll talk about is the concept of the fixtures, um, and the three basic tests to determine if an item has become a fixture. Fixtures are items of personal property that are attached to or incorporated into the land in such a manner as to become real property. The three basic tests are intent of parties, adaptability, and attachment. Excuse me. Intent of the property means did the tenant intend for the item to stay with the property? Adaptability means if the item is particularly adapted to the property, then it is likely to be a fixture. The last test is attachment, which determines if the item attachment is permanent, making it a fixture. Trade fixtures are fixtures that were installed for the purpose of conducting a business and are usually found with commercial and industrial tenants, not residential. Um, the second concept that I learned was the importance of lead-based paint disclosures. It's required for the owner to disclose these to buyers and renters for the presence of lead-based and or lead-based hazards found on their single-family residential dwellings. The lead-based paint disclosure and notification act requires the owner to provide the tenant with a protect their family from lead-based paint pamphlet from the EPA, which is a environmental protection agency for any housing that was built before 1978. The tenant must acknowledge this pamphlet and sign it, and the agent or the owner should keep it on record for 3 years. If the owner is to be found in violation of this rule, it can lead them to civil or criminal penalties. Um, the third concept that I found important from this chapter was the quiet enjoyment clause. The quiet enjoyment clause means that the landlord will not interfere with the tenant's right to the use of the property or the premises. A landlord can breach this clause by making noisy home repairs or wrongfully entering into the tenant's unit without their knowledge. A tenant can vacate the premises if the landlord breaches the lease in these manners. Um, they may be excused from paying the remaining rent on the lease, but if it does go to court and the law does determine that the landlord's actions did not breach the lease, then the tenant would be liable for all the remaining rent, even though they did leave the property. Um, in conclusion, Chapter 4 taught us a great deal about the many clauses that can be found in a standard lease. Fixtures and the three basic tests, the intent of parties, adaptability, and attachment are very important to remember. Determine if that item is a fixture. The importance of the lead-based paint clause is not only required by law, but for the safety of the tenants. Um, the last concept of quiet enjoyment allows me to live as a tenant in peace, knowing that the owner can't bother me whenever they want. Well, that's all for today, and I hope everybody learned something, and thank you for your time.